Ladies and gentlemen of the jury, the court instructs you that the mere fact that the plaintiff received an injury while she was working for the defendant does not mean that the plaintiff should recover a verdict in this case. The plaintiff is not entitled to recover a verdict unless she proves by a preponderance of the evidence the following propositions. Please bear in mind that by preponderance of the evidence is meant the greater weight of the evidence. First, the plaintiff must prove to you, the members of the jury, by a preponderance of the evidence that she was, at the time and right before she received the injury, in the exercise of reasonable and ordinary care for her own safety, that is, the type of care expected from a reasonably prudent person in the same or similar circumstances. She must also prove by preponderance of the evidence that she could not have prevented the injury to herself by the exercise of such care as would be shown by a reasonably prudent person. If she could have prevented the injury, then she was bound to do so, and if you find from the evidence that she did not do so, and that this contributed in any way to the happening of the injury, then the plaintiff is not entitled to recover a verdict in this case. Second, the plaintiff must also prove to you by the greater weight of the evidence that the top of the machine in question was in fact in an unsafe condition as charged by the plaintiff in count 1 of the complaint, and that the injury was caused by the unsafe condition and was not caused by any want of ordinary care on the part of the plaintiff as compared to that which would have been shown by a reasonably prudent person. Third, the plaintiff must also prove by the greater weight of the evidence that she did not herself know of such unsafe condition, and that she could not have known of it by the exercise of reasonable care as would have been done by a reasonably prudent person in the same or similar circumstances. If you find from the evidence in this case that the plaintiff has failed to prove by the greater weight of the evidence all or any of the elements as contained in these instructions which you have been instructed that she is required to prove by preponderance of the evidence, then you are instructed that she is not entitled to recover in this case, and your verdict must be for the defendant. You are instructed that there is no duty upon an employer to warn and instruct an employee as to dangers which would be obvious to a reasonably prudent person. If you believe from the evidence that the condition of the machine in question in this case was open and obvious to the plaintiff, then you are instructed that it was not the duty of the defendant to instruct her that such condition was dangerous. If you find that the plaintiff was injured as a result of such condition, then the plaintiff cannot recover, and your verdict must be for the defendant. Ladies and gentlemen of the jury, you are instructed that the plaintiff has alleged in this case that she sustained injuries by reason of the fact that the defendant negligently allowed a certain machine to remain in an unsafe condition. You are instructed that before the plaintiff can recover, she must prove by the greater weight of the evidence first that at the time of the accident, the place in question was not a safe place to do the work that was being done by the plaintiff. Second, that she did not know that the conditions were unsafe. Third, that she did not have equal means with the defendant to know of the facts concerning the condition of the top of the machine and the light around it and of the danger in such condition. Fourth, that the injury to her was sustained by reason of such dangerous condition. If you believe from the evidence that the plaintiff has failed to prove any of these four propositions by the greater weight of the evidence, or if you find that her injury was sustained by any other fact than that the top of the machine was not a safe place upon which to work, then you are instructed that the plaintiff cannot recover a verdict in this case, and your verdict must be for the defendant. You are instructed that the mere fact that she was employed by the defendant company and that she was injured at the time she was in their employ does not in law raise any presumption in favor of the plaintiff's right to recover in this case. Neither does the fact that the plaintiff has brought this suit, which has been tried before as a matter of fact, indicate that the plaintiff has any right to recover a verdict in this case. The law is that there can be no recovery against the defendant unless the plaintiff proves by the greater weight of the evidence that the defendant was guilty of negligence as charged in count 1 of the declaration, and that this negligence caused the injury of which the plaintiff complains. If you believe from the evidence that the defendant was not guilty of such negligence which caused her injury, then it is not liable and the plaintiff cannot recover against it. If, after you have considered all the evidence, you are in doubt and are unable to say whether or not the defendant was guilty of the negligence which caused the injury, then, in such case, you are instructed that the plaintiff cannot recover, and your verdict must be for the defendant. Ladies and gentlemen of the jury, if you will, please, I would ask that you give me your full attention for the next few minutes or so. All right.